Let me start by thanking the European Parliament for its positive opinion on the Commission proposal on the recognition of parenthood between Member States. And let me also thank the European Parliament for its continued interest in the ongoing legislative discussions on the proposal in Council and as shown by this oral question on the matter. Member States are already required by Union law on free movement to recognise parenthood established in another Member State for the purposes of children's rights under the European Union law. And this includes their right to travel or to take up residence in another Member State, their right to obtain travel documentation, or their right to be treated equally in a host Member State on all matters within the scope of the treaty. The Court of Justice confirmed in 2021 in its judgment in the VMA case that such recognition obligation also applies to children with same-sex parents, even if the Member State where recognition is sought does not allow parenthood by same-sex couples. And indeed, the recognition in a Member State of the parenthood established in another Member State is essential for the right to free movement. But families may still face difficulties in having the parenthood of their children recognised in another Member State for all purposes that is beyond the existence of children's rights under free movement law, notably for the purposes of children's rights under national law, such as their right to inherit from either parent in another Member State, to receive financial support from either parent in another Member State, or to be represented by either parent in another Member State on matters such as schooling and health. It is with this in mind that the Commission adopted the proposal under discussion and considered that, in line with international law, the treaties and the EU Charter of Fundamental Rights, the proposal should require Member States to recognise parenthood established in another Member State for all children, irrespective of how the child was conceived or born and irrespective of the child's type of family. The proposal does not affect substantive family law, which is a competence of the Member States. And the proposal is an essential element to build a union of equality and implements EU strategy on the rights of the child. Moving now to the two questions you have asked in the oral question. First, the Commission has followed and supported thoroughly the ongoing discussions in Council, which, however, need time and mostly for two main reasons. First, the proposal is a measure of family law with cross-border implications. The Member States have different approaches towards certain matters of family law. They therefore want to ensure that the proposal does not affect their competences to adopt rules on substantive family law, such as their rules on the definition of family, adoptions, or their rules on surrogacy. In addition, as the proposal needs to be adopted by unanimity, every Member State needs to be on board for every sensitive matter under discussion. Second, the proposal is technically quite complex. The proposal aims to facilitate the recognition of parenthood by harmonising the Member States' rules of private international law, that is, the rules on international jurisdiction, applicable law on the recognition of judgments and authentic instruments, and by creating a European certificate of parenthood, such as you have mentioned it. Currently, beyond existing rights under free movement law, each Member State addresses the recognition of parenthood according to different principles and procedures. Therefore, the Member States want to ensure that they find the provisions of the proposal acceptable from their policy viewpoint, and that their authorities will find the provisions clear. In view of the various policy and legal facets of the proposals since the adoption of the proposal, the Commission has at all times lent its assistance to the Member States, both in Council and in bilateral discussions, to clarify points, address their questions and listen to their concerns, to try to find common ground with other Member States. Likewise, the Commission has always been available to discuss with all Council presidencies technical and policy solutions within the scope of the proposal to help the discussions progress. The Commission also considers that all Member States have approached discussion in Council on the proposal in a constructive manner and that progress is gradually being made. Concerning your second question if the unanimity cannot be reached in Council, the Commission recalls in this matter that as the proposal goes beyond recognition of parenthood for the purposes of rights under EU law, it had to be adopted pursuant to Article 81, paragraph 3 of the Treaty on the Functioning of the EU, under the Union's competence to adopt measures on family law with cross-border implications. As the European Parliament noted in its oral question, this means that after having consulted the European Parliament, the proposed regulation must be adopted by unanimity in Council. Given that important provisions must still be discussed in detail, it is not possible at this stage to predict how negotiations will unfold. However, Member States will eventually need to take a stand on whether they can support the proposal resulting from the negotiations in Council, and if unanimity cannot be reached in Council, the Commission remains ready to consider possible avenues at that precise moment. Thank you.